Good morning and welcome to our second live presentation of the conference. If you experience any technical difficulties throughout the session, please go to the help desk in the top menu bar and use the chat live functionality to speak directly with our platform support. There will be a Q&A towards the end of the presentation, and we will also ask you to get involved in some poll questions throughout. You can do this by using the box on the right-hand side of your screen, by scanning the QR code you currently see on the presentation slide, or by going to slido.com and entering the reference number C179. I will now hand over to our speaker for this session, Jenny Laverty. Jenny, over to you.
Thank you. Hello, I'm Jenny Laverty, the Senior Manager of Lloyd's Complaints Team, and I'm going to be speaking to you today about our complaint handling rules and requirements and the adaptations we have made to our processes during the COVID-19 pandemic for each of our stakeholders. The agenda for today will be a recap on our rules and processes, including when it is necessary for us to mandate redress on a complaint when we cannot reach agreement with the managing agent, and how we oversee complaint handling within the Lloyd's market. I will only be speaking about Lloyd's complaints and not Lloyd's Insurance Company complaints. I will go on to talk about how we've had to balance the needs of policyholders and the market during the pandemic. This will be with regard to policyholders who have been affected by COVID-19, as well as our business as usual complaints. I will finish by giving you an overview of the process and system changes we have recently made to allow for more efficient complaint handling. At the end of my presentation, you will be able to describe the basic requirements of Lloyd's complaint processes and understand the factors we have taken into account when handling complaints relating to COVID-19. Let's first talk about the role of Lloyd's complaints team and why Lloyd's even has a complaints team. As you can see from this slide, we perform two functions. We oversee the handling of all complaints from eligible complainants within the whole market worldwide, but we also become involved in reviewing and making decisions on specific complaints when the complainant remains dissatisfied with the resolution proposed by the market, or in the UK when the market hasn't provided a resolution within the required timeframe. A complainant is considered to be an eligible complainant where they are able to refer their complaint to the External Dispute Resolution Service in their country or to the Financial Ombudsman Service in the UK. If the complainant doesn't meet the definition of an eligible complainant, there is no need for lawyers to become involved in this complaint. However, the managing agent must have processes in place to manage these. The Financial Conduct Authority in the UK considers all complaints on business underwritten in the Lloyd's market by managing agents or their representatives to be complaints against the Society of Lloyd's. This applies regardless of the territory in which the policy is underwritten or the location of the policyholder. It is Lloyd's that submits the complaint handling return to the FCA and engages with the Financial Ombudsman Service. In the UK, Australia, New Zealand, Singapore and Canada, there is a formal two-stage process where the complainant is provided with their right to refer their complaint to Lloyd's for a second stage review. Whilst it isn't part of the agreed process for other territories, we will conduct a stage 2 review if a complainant contacts us requesting one and we are able to add value with our review. Lloyd's involvement with complaints provides us with data that allows us to have oversight of complaint handling worldwide and ensure that they are being handled appropriately regardless of the location of the policyholder. The ultimate aim is to ensure that the policyholder outcomes improve and we are able to reach the appropriate outcome to the complaint without the need for the complainant to refer their complaint to an external dispute resolution service. I will now talk you briefly through the process flow for complaints. The first stage, regardless of location, is the investigation of the complaint by the managing agent or their representative. The complaint is notified to us so that we can ensure a response is issued within the appropriate regulatory deadline. Upon completion of their investigation, the managing agent or their representative will issue a response to the complainant and provide them with the appropriate referral rights if they remain unhappy. Copies of these responses are provided to us for review and to allow for the closure of the complaint. If the complainant does remain unhappy, they can exercise their referral rights and escalate the matter to us or their local External Dispute Resolution Service or the UK Financial Ombudsman Service. If the complainant refers their complaint to Lloyd's, they do not lose their right to ultimately request a review by their local external dispute resolution service or the UK Financial Ombudsman Service. Let's move on to the review of complaints. When conducting a Stage 2 review, our aim is to reach an agreed resolution with the managing agent. However, there are times when this isn't possible and we reach an impasse. In these situations, we do have the power to be able to mandate the resolution of the complaint on the managing agent. The complaints team has an award limit of £50,000, as well as requiring non-financial actions to be undertaken, such as requiring that an expert's report is obtained. If it is necessary to mandate redress of over £50,000, this is referred to the Head of Policyholder and Third-Party Oversight and Head of Market Development, with payments over £100,000 reviewed by the Head of Markets. We will issue a template pro forma to the managing agent, which will detail our findings. This pro forma will have been reviewed by another member of the team to ensure that our decision is correct. Managing agents can appeal against the mandate decision. However, this must be done within 2 working days, as we need to ensure we can adhere to the regulatory deadline. The appeal must be made by a senior nominated officer within the managing agent who can't be involved with claims or complaints. As required by the FCA's dispute resolution rules, Lloyd has a complaints code that sets out how complaints should be handled, and part of the code requires managing agents to meet certain requirements, and we have complaint handling performance metrics in place to monitor these. I won't go into detail about each metric we monitor, but they have been designed to ensure there is focus on key areas, which are to ensure more policyholders receive a comprehensive response within the regulatory deadline, to ensure that Stage 2 reviews are requested by the complainant and not as a result of an auto-escalation for UK complaints, as the managing agent hasn't issued a response, so that our resources are focused on those complainants that need our review, rather than us having to review complaints simply because the managing agent hasn't issued a response within 4 weeks of receipt. Also, to ensure that there are better decisions made at Stage 1 by increasing each year the target for the percentage of Stage 2 complaints where we are able to support the managing agent decision. We should be able to agree with the resolution of the complaint in more cases, and in turn, the complaints team within the managing agent should be able to support the decision of their claims team as the appropriate outcome to the claim. We conduct an annual review of these metrics to make them more challenging to drive continued improvements in complaint handling year on year. We review performance against the metrics on a quarterly basis, and the data is reviewed by the policyholder and third-party oversight management team, with decisions being made on any interventions that are required or remedial actions that need to be taken by the managing agent. This review feeds into the intelligence available to the Markets Directorate and feeds into our reporting to the executive team. Managing agents are provided with quarterly benchmarking data to allow them to assess their own performance for each metric, as well as see the performance for the market as a whole. They are also provided with specific feedback on our review of their data and the actions we require them to take. We do expect managing agents to take on board this feedback and make the necessary changes to ensure that their performance does improve and meets the required standard. Over time, it is anticipated that this oversight will be extended to cover holders and delegated claims administrators, although there is no time frame for this at the present time. If a managing agent does not meet our performance metrics, we are able to levy a compliance charge on them of up to £25,000. We can also levy this for systemic failures and not just for the failure of the performance metrics. We don't need for them to wait to fail the metrics before we can levy this charge. The level of the charge will be determined by a number of factors, including the nature of the issue, the metric failed, the impact of the failure, and the number of policyholders affected. The more policyholders that are affected, the greater the level of the charge, and metrics relating to responses or the quality of decision will attract a higher charge than those related to the notification of complaints. The first instance of a charge will not be made public, but we may publicise subsequent charges. We will, of course, take into account issues affecting the whole market when reviewing the metrics and levying compliance charges, such as we have done during the current pandemic. The policyholder and third-party oversight management team will make recommendations to the head of markets, who will make the decision as to whether it is appropriate to impose a charge. I will give you a brief overview of the UK FCA test case before I move on to explain how we have reacted to this. As you are aware, the COVID-19 pandemic and the government controls imposed in the UK have led to widespread disruption and business closures. This has resulted in a significant level of financial loss for businesses, particularly for small and medium-sized enterprises. A large number of businesses have made claims for these losses under business interruption insurance policies. In May 2020, the FCA announced its intention to bring a test case in the High Court to seek legal clarity about the meaning and effect of selected BI insurance policy wordings in the context of COVID-19 claims. The FCA was looking for a timely, transparent and authoritative judgment. It wanted to resolve the uncertainty over BI insurance cover and ensure that policyholders are treated fairly by insurers and insurance intermediaries. The FCA adopted the policyholder's position for the purpose of contesting these issues and contended that the relevant BI policies do cover the events of COVID-19 and the government action responding to the pandemic in the first half of 2020. There were two specific issues in dispute. The coverage issue. The insurers believe that certain BI policies they underwrite, which provide cover in principle for BI losses without the need for physical or property damage, may not cover losses resulting from the COVID-19 pandemic. And the causation issue. The insurers disputed whether, as a matter of law and fact, and in the light of the BI policies, the necessary causal link to losses suffered by policyholders that were being claimed for could be established, including the impact of any trends clauses or similar. Following the hearings, the High Court judgment was handed down on the 15th of September 2020. Certain parts of the High Court judgment were appealed, and where they weren't, the High Court decision remains. The Supreme Court judgment was handed down on the 15th of January this year and has completed the legal process for impacted BI policies. In most cases, the court favoured the FCA's broader interpretation of the relevant policy wordings and found that most, but not all, of the relevant disease clauses, which broadly cover the occurrence of a notifiable disease within a specified radius of the insured premises, do provide cover. Cover under these wordings is not limited to losses resulting from local outbreaks of COVID-19 only. Some of the relevant denial of access clauses, which broadly cover BI losses due to a prevention or hindrance of access to or use of the premises as a consequence of government action or restriction, also do provide cover. In relation to causation and the interpretation of some of the trends clauses, the COVID-19 pandemic and the government action were seen as a single cause of the covered loss rather than two separate events. Broadly, trends clauses allowed for adjustments to profit figures to be made to take account of any trends and other circumstances which may have affected the business, even in the absence of the insured event. And following the judgment, it was determined that payments could not be reduced as a result of the government lockdown. The FCA believes that the Supreme Court judgment gives insurers the clarity they need to conclude their claims processes with the majority of their BI customers without waiting for the declarations. The FCA has issued guidance and a Dear CEO letter setting out its expectations of firms dealing with BI insurance claims and complaints following the judgment. Throughout the COVID-19 pandemic, it has been necessary for us to balance the needs of policyholders, both those affected by COVID-19 as well as our non-COVID related complaints, with the needs of the market, as well as the Lloyd's complaints team. Taking into account we are all working in difficult and challenging circumstances. I will speak about each of these groups in turn, starting with policyholders. At the start of COVID-19, our initial priority was to assist policyholders in being able to make a claim under their policy. This is our usual stance when we are dealing with natural disasters such as hurricanes in the US. A COVID-19 hub was created on Lloyds.com, and we created a dedicated mailbox for policyholders to use to raise questions, and this mailbox was publicised on this hub. The mailbox was manned by experienced complaints associates, and it is still in operation today. We developed possible scenarios and standard responses so that these inquiries could be dealt with quickly and consistently. Throughout COVID-19, we have refreshed the data available on the hub as the FCA test case progresses. Following FCA guidance, it was necessary to put claims and complaints on hold pending the outcome of the test case. We continued to progress BI complaints that were not affected by the test case or related to claim delays. Policyholders were advised that their complaint was one that was affected by the test case, and so it was not possible to issue a final response at this stage. It was still necessary for us to meet our regulatory obligations and still provide them with their escalation rights to the Financial Ombudsman Service. As required by the FCA, we have provided updates to complainants on the test case as it progresses. Whilst it was the FCA expectation that the Financial Ombudsman Service would contact the complainants where they had chosen to refer their complaint to their service, after discussions with the Financial Ombudsman Service, we took responsibility for this and also provided an update to these complainants as well. Throughout this time, it has been necessary to balance the needs of all complainants to ensure their complaints are dealt with in a timely manner, including the increased number of complaints we received on travel policies as a result of cancelled flights and holidays. Whilst our primary focus during this time has to be the policyholder, we also need to ensure that we make appropriate adaptations for the market whilst not having a negative impact on the policyholder. In the same way as for policyholders, a COVID-19 hub for the market was created to provide information and guidance on how to deal with claims and complaints relating to BI. We had early engagement with managing agents to discuss our proposed approach to complaint handling and the best way to deal with those complaints that had multiple issues, some of which could be resolved and some of which needed to be placed on hold. The outcome of these discussions was to split the cases and issue a final response on the part of the complaint that could be resolved and only place the factors affected by the test case on hold. We reviewed all of our standard activities to consider what actions we could stop or delay without this having a negative impact on the policyholder or our regulatory obligations. Some of the actions we took were to allow managing agents more time to issue their stage 1 responses before we issued a chase, extending the deadline to provide their quarterly attestation to us and eligible complainant questionnaire, and not chasing for confirmation that actions required by our final response or the final Ombudsman Service had been completed. As updates to policyholders were required, we liaised with managing agents to ensure that all relevant complainants were provided with an update and no complainants were overlooked. And of course, we continued to liaise with managing agents to resolve complaints that were not related to COVID-19 to ensure that these were also progressed. Finally, we scaled back our performance metric review for 2 quarters as we understood that there was going to be an expected drop in performance due to managing agents having to work in different ways and the uncertainty about how to handle complaints affected by the FCA test case while we reviewed FCA guidance prior to putting the complaints on hold. We, of course, also had to ensure that the Lloyd's complaints team had the resources and support needed to be able to meet the needs of complainants and the market. Prior to the first lockdown, We ensured team members were able to work remotely and they had all of the documentation and resources required. It was necessary for them to ensure that they had their laptop, stationery, and copies of both Lloyd's leaflet and the Financial Ombudsman Service leaflet at home. We developed protocols to ensure that we could still correspond with complainants via hard copy letter, and we had the ability to be able to print and post these from home. We also developed a process so that complainants could still provide us with hard copy documents, and these could be scanned and provided to the complaints team. We have received at least 2 or 3 pieces of post this way each week. As the lockdown progressed, we had a greater understanding of the FCA test case. We collated data on the number of BI policies in place, how many claims have been received and declined, and modelled our resourcing requirements based on various possible outcomes of the test case. We secured executive team approval for this additional headcount prior to requiring it, so there were no delays when we needed to call on this. We have engaged third support to allow us to manage the additional workloads and tasks created by the FCA test case. During all of this, the health and well-being of team members was paramount, and my operational managers engaged with team members on a daily basis to ensure they were managing both from a workload perspective, but also a health perspective. The team created WhatsApp groups, had daily calls, and utilised the new technology available to us, as well as having remote team events to maintain morale. When it was possible to return to the office, we allowed members of the team who felt it would be beneficial for them to do so, but there was no expectation on people to return to the office if they did not feel ready. Throughout this, people's lives have continued, and we have had team members leave for other roles and challenges, and so have recruited new team members remotely and have onboarded them to the team, providing all of their training remotely. We have also continued to develop existing team members. Prior to the current situation, we have not seen a great deal of complaints relating to business interruption, and so it has been necessary for us to upskill in this area, and this is something we will continue to progress as the complaints move from claim delays and definitures to quantum issues. Before I move on to provide you with some data, I have a few questions that I would like you to ask you, so please respond using Slido. Firstly, how many complaints do you think we receive in an average year?
Thanks, Jenny. So just a reminder that you can answer this question on the right-hand side of the screen using the QR code on the presentation slide, or by going to slido.com and entering C179. So we've got some coming in, which is great. Just give it a few seconds for people to submit their answers. Lots of numbers coming in. The most popular by quite a bit looks to be 10,000 is the most popular answer there, but quite a few different ones coming in as well. 25,000, 1,000, 5,000. But yeah, the most popular is definitely 10,000 at the moment.
Thank you. So as you can see from this slide, this averages out at about 20,000 complaints a year. So double what people, the majority of people thought we received. So the next question, what percentage of our UK complaints do you think become escalated for a stage 2 review by Lloyd's? And there's 3 options here, 5%, 11% or 20%.
Thanks, Jenny. I can see the numbers coming in. We'll give it a few seconds and then I'll let you know what the most popular is.
Thank you.
Okay, so it's about 62% of us, or the audience, believe that it's 11%.
11%?
Mm-hmm.
That is correct. You can see from this slide that there was 9.2% escalated in 2019, with an increase to 13.1% in 2020, which gives us an overall average of 11% over the last 2 years. You'll also notice that whilst the overall number of complaints has reduced, the number of stage 2 requests we received has actually increased last year. Our final question. What percentage of BI complaints do you think have become escalated for a stage 2 review by Lloyd's in 2020? Again, we've got 3 options, 10%, 35% or 50%.
Thanks, Jenny. We'll just let those numbers come in. So it's looking very close between 50% and 35%, but I think 50% just has the edge.
Okay.
So that's the most popular. Yep, 50%.
Thank you. That is higher than the actual figure. You can see from the bottom table in this slide that our BI complaints, we've had 35% of them escalated in 2020. But now that we have got the decision on the test case, we are seeing a lot of complaints being escalated this year. So that percentage may increase and may even get as high as 50%. You can see that all the complaints that we've had related to COVID-19 have a higher escalation rate than our non-COVID related complaints. Moving on to the products that we are seeing, we've seen a significant change in the products that are being complained about. And as you would expect, motor, household buildings, contents and caravan complaints are reducing as people spend more time at home. And the largest increase we've seen is in business interruption complaints, with over a 2,000% increase. Commercial property policies also have provision for business interruption, so we've seen an increase in those as well. We've also seen a large increase in complaints relating to holiday homes as people claim for loss of rental income. And there's also been an increase in complaints relating to policies that impact people's personal finances, sort of payment protection and income protection. So turning now to the actual review of the complaints. At the start of the FCA test case, we developed a decision tree to be used by the team to allow us to triage complaints into those that can be resolved and those that were impacted by the test case and so needed to be placed on hold. As the test case progressed, this was reviewed and cases reviewed against it against the new requirements. We continue to review and issue final responses on BI complaints not affected by the FCA test case, such as those requiring physical damage to the property or those where there is a defined list of notifiable human diseases and COVID-19 is not named in the policy, as well as those that related to claim delays or service issues. As complaints were reviewed, we compared the actions taken by the market against the guidance that had been issued and dealt with any non-compliance issues so that the particular complaint could be resolved appropriately and future claims and complaints were handled in line with the requirements. We undertook a review of BI policy wordings against the questions being asked by the test case to understand the potential impact on these wordings and whether there was likely to be coverage. This work was undertaken on our behalf by KPMG, and the output was shared with managing agents to ensure that we had a common understanding of the likely impact before the judgment was handed down. We also took the opportunity to review what systems and tools are available to allow us to streamline our review of on-hold cases once the Supreme Court judgment was received, to allow us to resolve the complaints as quickly as possible. We reviewed the findings of the High Court judgment and progressed those complaints no longer affected and so no longer needed to remain on hold. Following the Supreme Court judgment, My technical manager has reviewed all policy wordings for complaints that were placed on hold and has provided our findings to the managing agents to obtain their agreement to our assessment of the wordings so we can progress and issue final responses on all of the on-hold complaints. Where there is coverage, we are advising the complainant that their claim will be reconsidered and the managing agent will be in contact with them to progress their claim. This has also allowed us to create a reference library of coverage per policy wording that can now be used to resolve new complaints as they are received, as well as inform the Financial Ombudsman Service of our approach for complaints that are escalated to them for review. Throughout the pandemic, we have engaged with the Financial Ombudsman Service to ensure we remain aligned with them as much as possible and to keep them updated on our approach to BI complaints. They did not have any guidance available on how to handle these complaints at the beginning of the pandemic, and they are also placing complaints affected by the FCA test case on hold. As previously explained, after discussion with the Financial Ombudsman Service, we issued the updates required by the FCA to complainants whose complaints were on hold with them. Following the judgments, we have reviewed the cases on hold at the Financial Ombudsman Service and advised them which of these we consider as having coverage and which are ones where the claim declinature will be maintained. We are updating them on specific policy wordings as our review progresses. They are following the same approach as us, and where there is coverage, are advising the complainant that their claim will be reconsidered and the managing agent will be in contact with them. Whilst all of this has been going on, we have continued to progress our process review, moving away from the use of spreadsheets and emails to sharing data and documents via secure, standardised messages. This has enabled automated and secure transfer of complaints data between managing agents and Lloyds and avoid the rekeying of data. Follow-up notification from Lloyds are also automated and complaint responses will be sampled rather than 100% check. This has greatly reduced the time taken to process stage 1 responses and manage cases throughout the process. The messaging has been developed by WorkSmart, who are the vendors of Lloyd's complaint system and who already work with a number of managing agents via their CareSmart system. However, it's being developed in such a way that it can be used between any managing agent's complaint system and Lloyd's, and a couple of managing agents are developing their own messaging functionality. There are a number of benefits to this change. Significant efficiency gains. A managing agent who has 100 complaints per quarter will save an estimated 25 working hours. A secure and GDPR compliant mechanism for exchanging complaints data, eliminating the need for email. No rekeying of data. Lloyds and managing agents will get a regular feed of complaints data going both ways. And better complaint outcomes. More time spent responding to complaints with less time spent dealing with administration. The development of this messaging functionality was funded centrally by Lloyds. This concludes my presentation, and so let's recap on the learning objectives of the session. You should now be able to describe the basic requirements of Lloyds complaint processes and have an understanding of the factors we have taken into account when handling complaints relating to COVID-19. So now we can move on to any questions.
Great, thanks Jenny. Yep, so just a reminder that you can ask your questions on the Slido box on the right hand side of your screen by scanning the QR code or by going to slido.com and entering C179. With that, we will kick off the Q&A. We've got some questions coming in already. So the first one, Jenny, when you're ready.
Yep.
How does the Lloyds Insurance Company complaints process differ from the Lloyds of London? Is there a link between the teams?
We do have regular engagement with Lloyds Insurance Company's complaints team, but the complaints processes are different. Most notably with UK complaints, they do have some UK policyholders, so they will be handling some UK complaints. And for Lloyd's complaints, we have a two-stage process, but Lloyd's Insurance Company don't have that two-stage process. And the other main difference is that there are different times frames depending on whether the business is written via freedom of establishment or freedom of service. But for Lloyd's complaints process, we don't make that differentiation. We deal with them all in the same way. So that is probably the main change, but also that these are, for Lloyd's Insurance Company, they are complaints against Lloyd's Insurance Company. So they do become involved with actually issuing responses for that initial the initial resolution of the complaint, where Lloyd's complaints team don't. We would never issue that first stage response.
Great, thank you. So the next question is, where do I find the Lloyd's COVID-19 hub complaints information?
It's on Lloyds.com. So if you search for coronavirus or COVID-19, you should find it. I'm sure we can probably share links to it. I don't know if information is going to be going out at the end of this conference, so we'll be able to share links to it in that.
Yeah, we can do a follow-up comms with some links. That's great. Next question. Is it expected by regulators to have this type of complaints process in the US territories?
There is a complaints process in the US, so we have complaints processes worldwide. We only have information on Lloyds.com for complaints processes where there are a significant amount of policyholders, but where we don't actually have something on Lloyds.com, managing agents should still be adhering to local requirements. So in the US, we have a specified definition of a complaint, and it has to be a complaint in writing, and they have 8 weeks to resolve that complaint, unless it's a complaint that's obviously come through the Department of Insurance in the US, in which case you need to meet their deadline, because they have case-specific deadlines. So there is information on Lloyds.com. So if you search Lloyds.com/complaints handling, you'll find guidance there on worldwide complaints, Lloyd's expectations.
Great, thank you. Another question around the US. Are you seeing COVID BI complaints from the US where most decided cases have favoured insurers?
I don't really have a lot of information on that, because we're not involved in a second stage review of BI complaints in the US. We have had an increase in the number of US complaints that are reported to us, but I don't have the data to hand whether there is how many of those would relate to BI. If you are interested, I think if you submit that question to the events mailbox, we'll be able to provide you with some data.
Great, yeah, if you just want to submit that question to events@lloyds.com, then we will be able to get back to you. Thank you. Another question, when was the last time that a cover holder was refused registration due to ongoing complaints or bad practice?
I'm not involved in cover holder registration, so I wouldn't be able to answer that one, I'm afraid. So again, email that one in, and I'm sure someone will be able to provide a response.
Great, thank you, Jenny. Yeah, just again, if you just want to email that to events@lloyds.com, then we can pick that up offline. Okay, we've got a couple more minutes left, so we'll just ask another question that's come in. Has Crystal now been updated with the varying complaints regulations?
Again, I'm not responsible for Crystal, but there is, I believe that Crystal does show you Lloyd's complaint requirements and Lloyd's Insurance Company requirements. But if you had any questions on that, I think the litter@lloyds.com email address would be the right one to ask those questions, because the regulatory team are responsible for maintaining Crystal.
Thanks, Jenny. We haven't had any more questions come through at the moment. Was there anything else that you wanted to add just at the end? We've got a couple more minutes left. Is there anything else you want to add, Jenny?
I don't think so. Hopefully people found the presentation interesting and useful. It's been a challenging time working in a pandemic, hasn't it? We've increased volumes, but hopefully with the test case, we're now able to get some clarity on these complaints, and we'll be able to move these forward for the policyholders.
Great. Thank you very much, Jenny, and thank you everyone for attending and watching today. We're now going to come to the end of the presentation as we've got no more questions coming through. So we hope to see you for the next presentation at 2:15 this afternoon. Thanks.
Thank you.